Welcome to Law and Crime Network's Law and Crime Report. I'm your host, Bob Bianchi. We are gavel to gavel on one of our new trials during this COVID-19 pandemic, which we will get to the complexities with that. With regard to Erica Stefanko, 37 years old, it's out of Ohio. She's being charged with having conspired with her then husband, Chad Cobb, to kill Chad Cobb's ex-girlfriend in this really bizarre and twisted scenario. Cobb ultimately was caught a day after the murder of the victim, Ashley Biggs, who was 25 years of age at the time. He gave a confession to police. He pled guilty in 2013 to a sentence of life without parole in order to avoid the death penalty. Now, all these years later, in 2019, Stefanko, the ex, is now on trial as a co-conspirator in that murder, only charged in 2019, and her ex, Chad Cobb, as well as Chad Cobb's 15-year-old daughter, are expected to testify against her for the prosecution. So it's been a very, very interesting and fascinating case. Prosecutors don't have a tremendous forensic case, but it's really not a big forensic case. There's a lot of other ways for prosecutors to prove cases, especially through the credibility of witnesses. We'll see about that. Let's listen to how the prosecutor is going along, trying to prove the case brick by brick in their opening statement.
They get back to the scene. However, it's not as they planned. The police are already there. So what do they do together? They go to 731 Rex Lake Road, the house you see, and hid behind the detached garage. And that is where they were ultimately apprehended. Erica was in the car with the 4 children. Chad Cobb was hiding in the woods. Now, ladies and gentlemen of the jury, evidence and testimony will show a variety of different things from a variety of different sources. I want to bring out 2 main ones you'll see in here. One, Cindy Cobb. Cindy Cobb secretly recorded a conversation with Erica Stefanko. During that conversation, this, in essence, you're gonna hear it straight from Erica Stefanko's mouth, because it's her voice on the recording. During that secretly taped conversation, the defendant admitted to making the phone call, Cindy Cobb asked her, "You told me face to face you made the phone call and set up the meeting." The defendant, Erica Stefanko's response, "There's no lie in that. Chad said, this is what we're gonna do. This is your part in it. I carried out my part. I did what he told me to do. It wasn't like he was forcing me to do it. Again, it wasn't like he was forcing me to do it. Wasn't like he had a gun to my head." I want you to please keep in mind complicity. Because again, whether or not you choose to label Erica as the principal or the accomplice, she is still guilty of aggravated murder, kidnapping, and aggravated robbery. For it was the defendant, Erica Stefanko, evidence and testimony will show, that made the call. It was the defendant, Erica Stefanko, that waited and followed Chad Cobb to drop the body off. It was the defendant again that waited while he drove the car into the cornfield and came back. It was the defendant again who saw him a bloody mess, took him home so he can shower. It was the defendant again with Chad Cobb that drove back to the scene with cleaning supplies to clean up that area. And finally, it was the defendant again that hid with Chad Cobb.
All right, there's the prosecutor. Let's give a little context here. The argument in theory of the prosecutor is that Erica Stefanko, who's now on trial, actually made a phone call to lure the victim, Ashley Biggs, to a abandoned location where Chad Cobb had killed him. And now we hear Cindy Cobb, which is the mother of Chad Cobb, has this conversation apparently where there may be an admission. And on top of that, we have the potential of the 15-year-old daughter of Chad Cobb, who's going to come in and talk about this phone call in order to have this fake pizza delivery, which was really a setup. But let me bring in my two guests, excellent people. Jillian Gross out of New York, former ADA out of the Bronx County DA's office, does matrimonial and family law now, and is a rising star and super lawyer. Welcome to the show, Jillian. And we have Joseph Scott Morgan with us, former senior investigator at the ME's office out of Atlanta, a distinguished scholar of applied forensics at Jacksonville State University, and a board certified American Board of Medical Legal Death Investigators, and the author of Blood Beneath My Feet. I just love it. I love saying that term of that book every day. So guys, the prosecutor's laying out, Jillian, let me go to you first, a very strong case about motive, means, and opportunity. What are your thoughts about, I think the prosecutor's doing great. What are your thoughts about how she's presenting this case to the jury? It is a circumstantial case with a defendant, Erica Stefanko, who had not been arrested for years later.
I think she's doing a fantastic job. She's clear, she's concise, she's speaking on a level that anybody can understand, and she is painting a very, very grim picture of a plan and how that plan was carried out.
Joseph, I know that we have talked about this case offline, a little bit about the forensic aspect of it, and usually you have a much more heavily forensic oriented case, but you point out that forensics are still involved here because there's kind of like 3 separate crime scenes. Talk to us about what we can expect is going to come out from a forensic point of view.
Well, I think that dependent upon, the point of origin where she was summoned to, I think that that's going to be critical here in painting the picture. What type of evidence may or may not have been recovered there, and how carefully was it preserved, kind of moving forward. And also from within these vehicles, I had mentioned there are actually 3 scenes involved in this. You have where the assault or the attack took place. You have this kind of transport zone, and then you have the final resting place, which in our parlance, when you're talking about a body, that's going to be the primary scene because that essentially contains the most evidence. I got to tell you, Bob, one of the really striking things for me is this whole angle of luring her in. I've worked actually in my career in New Orleans and Atlanta a couple of cases like this involving delivery drivers, and there is there's a certain another ominous level to this because it goes to planning. It's not like someone just breaks into a house and beats somebody to death or chokes them out and takes everything that they have. This requires some planning and understanding the environment around there. And that's why, it makes this kind of confederation, come together, conspiracy kind of come together, because there would have had to been some planning and coordination along the way with this. So, it's going to be very interesting to see how the prosecution exploits that particular detail.
Okay, going to be interesting. Now, Chad Cobb, who pled guilty to avoid the death penalty to a life without parole, prosecutors say he was given no incentive, no offer to testify in this case. He's doing it on his free will. He's waiving the spousal privilege. Maybe we'll get an opportunity to talk to you a little bit about that. Of course, the defense is saying, no, he's doing that because he has an expectation of benefit. I assume they're going to say the same thing with regard to the 15-year-old daughter who's going to testify. So they definitely have grist the defense for the mill here. Sometimes there's an adage, when you sleep with dogs, you catch fleas. So yeah, lots of times prosecutors have to use, not so great witnesses, and they have to try to find other evidence to support that testimony. The question is whether the jury is going to believe those prosecutors' witnesses. It's totally capable of happening. We used to do it all the time prior to the advent of all the forensic science that we have right now. Let's listen to the defense attorney in their opening statement.
The whole purpose of an opening statement is to give the jury a roadmap, a guide as to where this trial is going to go and what the evidence will show you. And at the end, you people will be given instructions from Judge Jones when you go into your jury room is to begin your deliberations. But what I'm going to ask you to do, and what Judge Jones will tell you in her instructions, is you should not discuss the evidence before you get to your jury room. And hand in glove with that, I'm asking you not to make any preconceived decisions. A fair trial is guaranteed by the Constitution of the United States. And part of that fair trial is that you wait to hear all the evidence. We talked to you during jury selection about the fact that the state may have more witnesses, they may have several, if not a lot, police officers, BCI people, law enforcement. And we asked you, just because they are law enforcement, you know, they are to be believed by the same tests that you would believe anybody else. Wearing a badge, carrying a gun, having a degree from BCI in chemistry or biology does not imbue these witnesses with some special status. Witnesses can be believed all of their testimony, part of their testimony, or none of their testimony. That's your decision.
Yeah, so Jillian, let's talk to our audience a little bit about how prosecutors formulate opening statements and defense attorneys. Prosecutors are responsible for doing an opening statement that lays out all the essential elements of a crime by law. The defense has to do nothing. They could sit there and say, "Thank you very much, Judge. We're not going to make an opening statement," or they can get up and really attack the case and the facts, or they can do what this lawyer did, basically, was advise them of all the things they're going to hear from the judge with regard to how they're supposed to manage the evidence in the case. What were your thoughts of the defense's opening?
I think a little bit more of the attack would have been helpful. I think it's important to manage, and it's important to give them that instruction of how they deal with the evidence. But I think it would be good to hear a little bit of an attack of what the prosecution is saying happened here.
Yeah, Joseph, I don't disagree with Jillian. I was always I'm always an attack dog, whether I'm one side or the other side. But like, you know, I would be kind of peppering this with this case that for what has it been, 13, 14, 15, 16, 17, 18, 19 that our client wasn't, you know, responsible for. And they're going to ask you to take the word, take this, folks, take it to the bank from a convicted felon, not just a convicted felon, a person that committed a murder, not just a person that committed a murder of the victim in this very case. And guess what she did after she participated in that, or what happened with all this, Erica Stefanko divorced him. She divorced him and he was angry and he was agitated and he's looking for a break. He's looking for an expectation of a benefit. Don't let him tell you otherwise. There's a wink and a nod, folks. Listen carefully to the testimony because you're going to find that this case is built on house cards. Something like that, Joseph. I don't know.
Yeah, it's almost like going through his file and see, okay, boilerplate, I got it right here. This is what I'm going to do. Here's my opening statement. And I know you don't want to hear that. Most attorneys would not. As a non-attorney, that's my takeaway with this, because I didn't come away with any more knowledge or any more understanding. But, you know, it's to your point, you know, it's like you said, he doesn't necessarily have to lay out a case. I've always viewed this is they want to attack credibility of evidence. And this goes back to what he was saying again, and you knew I would pick up on this, Bob, about what he was saying about the experts that are going to be testifying in this. And you're right, just because you carry a badge, just because you carry a gun, just because you're degreed, does not necessarily mean that what issues forth from your mouth is gospel truth. However, at the end of the day, is the prosecution going to be able to take all those figures and numbers and computations that we do in the lab and elsewhere and present it in a lucid manner to the jury? Again, keep it simple, stupid. Just put it out there. Let the jury make the determination on it at the end of the day.
Right. Prosecutors certainly want some sort of objective evidence to support the witness's credibility, who is clearly going to be easily attacked. Whether the jury buys that or not, listen, they get to look at a witness. Some people say, how can that be? Yes, you can evaluate a witness and find somebody guilty just on a witness's testimony. It'd be interesting to see if there's phone records in here. I know we talked about that offline, Joseph. You made a good point with that when we discussed the case. Guys, we got a lot more here at the Law and Crime Network. We're really excited, as you can tell, about this case. Stay with us. We'll be back on the other end. Okay, the Erica Stefanko case is underway. Prosecutors and defense lawyers giving opening statements today. We've been listening to part of the defense opening statement. They have stuff to work with in this case. Let's listen to a little more.
After 6 or 7 months, possibly longer, and we get into early 2013, I believe it is, he then stands in front of a judge and admits that he beat and strangled and was guilty of aggravated murder of Ashley Biggs. His indictment has his name alone on that indictment. At his sentencing, he never mentions that he has a co-defendant or an accessory before the fact or after the fact. The judge asked him if he has anything to say. The fancy phrase for that is allocution. He never mentions Erica Stefanko's name. Ladies and gentlemen, we have a person who, after 8 years now, after never mentioning it before, until really about 2017, he's stewing in that prison. And now he's trying to get out from under full responsibility, because he wants to drag somebody else down to his level. He wants to get out of prison early. He wants his sentence shortened. Ladies and gentlemen, this is the kind of person that you are going to try to evaluate. Someone that took the mother of his daughter, ambushed her, beat her, and strangled her. And you are going to determine how much truth is in his statement. Why would he do all this? Well, after he's been in prison for about a year or two, Erica, and he's in prison, by the way, the penalty is life in prison with no possibility of parole. Simply put, he must die in prison, whenever that is. So, he is desperate. His family is desperate to shorten his sentence, to get out early any way he can. You will see and hear from 1 or 2 family members. Once again, you are free to believe all, part, or none of what they say. That's part of your job. He's been in prison, and now Erica, after a year or 2, files for divorce. And then Erica remarries, and she remarries Chad Cobb's good friend, who also worked for him, a person by the name of Christopher Michael Stefanko. They got married in about 2015. They have 2 children of their own. You will hear from Christopher Michael Stefanko when the defense has their turn. Ladies and gentlemen, I'm asking you to listen to both sides, the state and the defense. There will be a lot more witnesses for the state than there will be for the defense. One of those reasons, the state has the burden of proof. That's their job.
All right, there's the defense's opening statement. Joseph Scott Morgan, I gotta say a mea culpa. The defense lawyer got there for sure. He tied
Yes,
it up.
he did.
He went into the specific facts. He went into the motive. He went hard at them as to why it was that the prosecution's case does not hold water. So overall, a very effective defense opening statement. It wasn't just bland and vanilla. You got to follow the law, follow the rules, give us a shot, give us an opportunity to listen to our evidence. And let me explain to you a little bit about this guy who's going to testify against her and why. What did you think?
Oh yeah, I thought that he went from boilerplate all the way to specificity here, and he really laid it out as to what they're going to do, and he put the burden, as it well should be, on the prosecutors in this particular case. They're going to have to prove this case, and listen, with defense, all they have to do is exploit one specific area of the prosecution's case and make the whole thing tumble down, and that's what they're about here, and they're going to attack credibility here. From what does all of this arise? What are his motivations? And I thought that was kind of compelling. What he mentioned, he used the word stewing, that he's been sitting in prison all of this time, wringing his hands, thinking, what can I do to get out of this place?
Jillian, thoughts?
I actually think completely different than I thought before. Started off really boilerplate and boring. I agree. He nailed it in the middle, and then he brought it back at the end to, what the jury has to do with what they're told. I think he made it clear that credibility is really the important factor here. And without all the forensics, the credibility is really what's going to hold true. So as Joseph said, you put one chink in one of these people's testimony, it's going to be very interesting to see what happens.
And Jillian, you would agree in an opening statement, opinions are being formed irrespective of them being told not to. So that was a good thing that he did, because he probably has those jurors going, like Arsenio Hall used to say, you never, what did he say? Well, he used to say that statement all the time. Things that make you go, Anyway, Jillian, thanks so much for being here. Joseph Scott Morgan, you're not going anywhere. I know I'm going to get it. We'll be right back after the break.